services. If for some, I guess if there's a problem, we'll call back. If you don't answer, then we'll reset it till tomorrow.
Very well, Your Honor. You have a wonderful weekend.
You too. All right, is this William Jennings? All right, sir, you've been arrested for the offense of battery and act of dating violence. I do find probable cause for that offense.
What was the probable cause?
Sir, I'm not going to argue with you. I've read the affidavit. I've made that determination. It appears that you qualify for pretrial release. I'll order your release through the pretrial release program. I'm going to order that you have no contact whatsoever with the victim. I'll order that you maintain a separate residence from the victim. I'll order that you may go back one time to any shared residence in order to recover any personal items you need while the case is pending.
I have a
That-
lot of stuff that I,
That must be in the company of law enforcement. Sir, I want to emphasize personal items that you need to survive while the case is pending, not all property that you might think at some point in time you have an interest in, all right? Order you not possess any weapons, firearms, or ammunition. That is the order of the court in regards to Mr. Jennings.
Your Honor, how does that pre-trial, how does that work? I don't know how that works.
The pretrial release staff will go over that with you, explain all the conditions of pretrial release, how to report, and then you'll be released, all right?
Thank you.
You're welcome.
DeCavius Burton knows a refusal.
We'll invite Mr. Burton to come back tomorrow.
Your Honor. Your Honor, if he's appointed to us, I would waive his appearance.
All right. So Mr. Burton was arrested, I believe, on a warrant. So the bonds on the warrant will be stayed as previously set. Is it just one warrant or does he have two? Okay. And he is out on release on a driver license suspended. I'm going to revoke the bond in that case, or he be held on a no bond status until that case is disposed of. All right, all conditions of the warrant, including the bond and any other conditions, are stayed. All right. Next I have is Michael McAuliffe.
Yes, Your Honor.
All right, sir, you've been arrested for the offense of violation of domestic violence injunction. I do find probable cause for that offense. I'm going to set bond in the amount of $1,000. And I'm going to order, as a condition of your bond, you comply with all conditions of your currently active injunction, sir. Do you understand?
Yes, sir. Yes, Your Honor.
If you were to violate again, and it was established you violated, you should assume that your bond would be forfeited. You would be placed back in the Orange County Jail, and you should not assume that you would get back out while your case was pending. Do you understand?
Thank you so much.
All right.
Your
That
Hon-
is,
I'm sorry, Your Honor, Judge Wooten, the victim, we spoke with the victim yesterday, and under the protection order, she just wanted to make sure that, part of that, protection order, the subject has visitation or custody rights, so she just
I
wanted.
saw that. That's why I ordered him to
Okay,
comply
good.
with
Thank you,
all
Judge.
conditions of the injunction. So whatever the injunction says about child sharing, whatever,
Okay.
that stays in effect unless the injunction judge modifies the injunction. But you have to follow all of those rules. Do you understand?
Yes, Your Honor.
All right. That's the order of the court. Next I have is Brandon Banks.
He was a refusal. Your Honor, we'd waive his appearance.
He was arrested for trespass on property after a warning. I do find probable cause for that. I'm going to stay his bond at $500 and order if he posts bond that he not return to the location of the alleged trespassing. The next I have is Tyler Farmer. Good morning, or excuse me, good afternoon, sir. Tell me your name.
Tyler Farmer,
Mr. Farmer, you've been arrested for the offense of trespass on property after warning. I do find probable cause for that offense. I'm going to stay your bond at $500. I'll order if you post bond that you not return to the location where the alleged trespassing took place. That is the order of the court.
Your Honor, does the court of this, or the state have an offer for this charge?
His last conviction for trespass was on November 29th. The state's offer would be 7 days in the Orange County Jail with credit for time served and a no return,
Would that be an adjudication or withhold?
an adjudication.
Your Honor, may I have a moment?
Sure.
You signed it. Your Honor, would the court be willing to take that offer at this time?
That's the state's offer under the circumstances. Mr. Farmer, is this how you want to resolve your case? As you stand, did your public defender talk about all the rights you give up when you enter a plea at this stage in the process?
Huh?
She explained to you all the rights you have when you enter a plea at this stage of the process? Do you understand the public defender's not going to work anymore on your case? You're just going to get your 7 days. When your 7 days is up, you're going to be released? You understand that?
Sir.
You understand I'm required to order you to pay court cost, and I'll give you a year to do that. Do you understand that? Okay. And did you sign this plea form?
Yes.
And do you believe you understand what you're doing by entering this plea today?
Yes.
I'm going to accept your plea. I find you're alert and intelligent. Your plea is freely and voluntarily understood. You understand the nature of the charge against you, represented by competent counsel, with whom you say you're satisfied. I do find a factual basis. I'll adjudicate you guilty. I'll sentence you to 7 days in the Orange County Jail with credit for the 3 days' time served you already have. I'm going to order that you pay all statutorily required fines, fees, and costs associated with this misdemeanor conviction. Madam Clerk, do you happen to know the amount?
Okay.
273.
Probably true.
273.
Sir, it's court cost of $273. I'll give you 1 year from today's date to pay those costs in full, or I'll order within 60 days of today's date, report to the clerk's office, room 410, at the downtown courthouse to set up a payment plan. Do you understand those two choices?
Yes, sir.
All right, that's the order of the court.
Thank you, Your Honor.
All right, next is Nathaniel Titus Lynch.
You doing Mr. Langford? Is that who you want first? Yes. Hey, that's the judge, yeah. Okay.
Good morning, Your Honor. Ronald Lejean on behalf of Mr. Lynch.
Nathaniel Titus Lynch. Oh, I've got his order.
Okay.
You're on that side.
Sir, tell me your name.
Nathaniel Lynch.
Sir, you've been arrested on a warrant signed by Judge Egan. It's 2 counts of lewd or lascivious battery. Mr. Lejean, what do you want to tell the court?
We'd request a reasonable bond with reasonable terms, Your Honor.
So here's the challenge I have at this point. All I have is Judge Egan's warrant. I don't have an affidavit to provide any additional information for the court to really assist me in setting bonds. What I'm inclined to do is leave it as set by Judge Egan, let you get in front of the division judge, have a full-blown bond hearing.
Well, we believe he's entitled to some amount of bond, and that normally that might be easy to do, but this time of the year, that is probably not going to be very practical to do. So we request some type of bond here today.
State, any thoughts on what an appropriate bond would be under these circumstances?
One moment, I'm trying to pull the paperwork out.
He does have a 5-day hold for probation as well.
Well, I thought I saw something about him also having, wasn't he on sex offender probation?
Yes, there's a 5-day hold, Your Honor.
So, Mr. LeJean, he's not going anywhere.
All right.
So under the circumstances, rather than set a bond now and then you have to argue with another judge later as to why to change that, I'll simply indicate that I'm going to leave the bond in place and allow counsel to set a bond hearing in front of the assigned division judge.
Thank you, Your Honor.
All right. Next is Viviana Roy Caballero.
Rose Hernandez covering for Loose Root on behalf of Ms. Caballero. We'll waive the reading of the charges in this case.
Okay. Tell me your name, ma'am.
Viviana Roy Caballero.
So, ma'am, you have been arrested on a warrant. So again, I'm in a situation where Judge Nick signed the warrant, but I don't have an affidavit with it. Have you located an affidavit?
No, Your Honor.
State?
No, Your Honor. I did see the signed order by Judge Nix Walker. She did indicate that it would be a zero bond. I don't have the affidavit supporting that warrant. I can try to get it this afternoon for tomorrow. Based off the charges, though, the state would be asking for no bond. I do understand defense's wish to have the affidavit handy, though.
All right. Mr. Hernandez, I think the only thing I can do under the circumstances is reset it for first appearances tomorrow, see if we can get the affidavit in, and then both of y'all can make an argument about what a reasonable bond would be under the circumstances.
That's fine, Your Honor.
All right, I'll reset Ms. Caballero tomorrow. I'll give the state 24 hours to obtain the affidavit and present it to the court.
Thank you.
You're welcome. Next is Victor Alfonso Carrion.
Good afternoon, Judge. Jose Rivas here in the matter of Mr. Carrion. Judge, we would just like to ask for a reasonable bond on this, Judge. Mr. Carrion lives in Chicago, Judge. He resides with his parents. I can take some testimony as to that, but I understand he doesn't have any ties to the community, Judge, but we would still ask for a reasonable bond in this matter. I've spoken to the state. Not sure I've gotten their response yet, Judge.
Well, again, I've got the warrant that was signed by the judge. Count one is a first-degree felony punishable to life in prison, which means the defendant's not necessarily entitled to bond. And I don't have an affidavit that explains the underlying facts for the court, so.
Judge, I do have an affidavit. I don't know. We must have gotten it off the clerk of court.
The state has reviewed the affidavit. It's our position that the first count, since it is a PBL, the state would be asking for no bond. On the other counts, he is entitled to a bond, and we would not object to the court setting bond for those.
You have any objection to Mr. Rivas showing me the affidavit?
No, Your Honor.
Thank you. Mr. Rivas, the affidavit is troubling to the court, particularly extent that it appears the victim in this case had already sought the protection of the court in the form of an Illinois protective order and injunction, and it appears the defendant has allegedly violated that by forcing his way into a residence and committing various crimes therein. So I'm not inclined to grant bond on count one at this time. I'll set bonds on the other counts although it's not really going to have any impact on what happens with the defendant at this point in time.
Judge, as to the injunction, Judge, I understand it's listed in the affidavit. I have not seen any kind of paperwork or nothing to support that particular charge, Judge, other than the allegation.
That certainly might be something to raise in a full-blown hearing in front of the assigned division judge, once everyone can actually get their paperwork. The affiant indicates that he reviewed the paperwork and checked in teletype and showed that it was served. So again, at this stage, we're dealing in analysis of probable cause and the strength of the case. So what ultimately might happen down the road is neither here nor there. So I'm going to deny the request to set bond on count one. Do you want me to set bonds on counts 2 through 6?
No, Judge.
All right.
We'll address that at the.
Okay. That is the order in regard, and I'll return the affidavit to you so you don't have to generate another copy. All right. So, State, if you had a chance to review the defense's motion for ROR on these cases that are not before the court today?
I reached out to my supervisor just to verify, and those are something she said that needs to be handled on Monday. The motions were filed yesterday, I believe, afternoon. They are not my cases. We don't handle 33-day motions on Saturdays and Sundays, so there's nothing I can do about those today.
Mr. Rivas, you would agree that the rule allows the court to give the state additional time to determine if they're going to charge or not, correct?
Well, Judge, the rule is very clear. I mean, on this, after 40 days, Judge, if they haven't filed, I believe the case is right now 37, 38 days, Judge. And I would point out, justice doesn't stop on the weekends. You know, I mean, it's been it's 36, 38 days, unless they show good cause. You know, the fact that we don't do this on the weekends is not good cause, it's not allowed for in the rules, Judge. It's pretty straightforward that he shall be released, you know, after 33 days, Judge.
I'm going to give the state until Monday to either file or concede that your motions are well-founded.
Okay.
I believe that's, under the circumstances, a good cause. Otherwise, I'm asking an attorney who's not been noticed, not been assigned to the case, to try to make a decision under the circumstances. So I understand your desire to get it addressed, but I think that would establish good cause as contemplated under the rule.
Judge, again, they've had 38 days to file, Judge. I don't know what else they would do on the weekend they couldn't have done in the last 38 days, Judge. You know, and again, I would argue that, you know,
I understand the argument,
it's not allowed for in the ruling, Judge.
but the rule does contemplate, in other words, this is not truly automatic. The rule contemplates this opportunity for the state to make the decision to file. And I agree that there needs to be some form of good cause. I think under the circumstances that we find ourselves in right now, that constitutes good cause.
So
That
the
the
courts,
attorney who should actually be responsible for the case should have an opportunity to review it and determine if they're ready to file, in which case that obviates the decision, whether they're going to concede that he should be ROR'd, or whether they have additional good cause for the last couple days they have access to. So that is my order in regards to these cases, Mr. Rivas.
Judge,
I'm not taking any additional argument.
okay, Judge.
All right.
All right, so will the order say that it's going to be readdressed again here on Monday or automatically released on Monday if they haven't? Will the court at least agree to automatically?
I'm not going to rule on the motions today. I'm going to give the state until Monday. You can, which judges are they in front of?
There's 3 different judges.
Okay.
That's the thing. So can it be reset for here on Monday? I mean, because there's no way we sent an email, we haven't gotten any response back, Judge. I mean,
Which
again, being that
judges?
it's the holidays.
Which,
Osceola cases, Judge, so it wouldn't be here to be done in Osceola.
Need to be done down in Osceola in front of one, at least one of the 3 judges assigned to those cases.
Okay,
All right?
okay, Judge.
All right. Damari Fuller. Sir, tell me your name.
My name is Damari Fuller.
Good morning, Your Honor. Afternoon, I'm sorry.
Afternoon, Mr.
I'm
Mike.
Robert Mike here on behalf of Mr. Fuller.
It's nice to see you.
It's good to see you, Judge.
So, Mr. Fuller's got, looks like 2 matters before the court. The first is his new arrest for carrying a concealed firearm.
I understand.
Yes.
Thank you.
There's a bond on that case, and the case that we're here,
Hold on one second.
I'm sorry.
So I do find probable cause for that. I'm going to stay his bond at $2,500 on that case. Then the second issue is that he has a warrant arrest for a robbery, firearm, aggravated battery with a weapon, grand theft to the 3rd degree. That warrant was signed, looks like by Judge Young. He set bond on count 1 at none, bond on count 2 at $3,500, bond on count 3, $1,000. So what are you asking me to do today, Mr. Mike?
Judge, we're asking for bond as to count 1 of that charge, the robbery with a firearm. And we do understand that it is an F1 PBL, but we believe that under the circumstances, the probable cause issue, we believe that the proof is not evident and the presumption is not great as to his guilt. And we draw that conclusion from the probable cause affidavit itself, which is internally conflicting. I believe if you, as I reviewed it, there are a couple of stories that are told. And this
Mr. Mike, let me interrupt you for 1 second.
Yes.
So, my reading of the law is in a situation like this, the court can defer the Arthur hearing to the assigned division judge, which would be Judge Young down in Osceola. And I think that's the appropriate thing to do under the circumstances. He's the one that reviewed the affidavit. He's the one that made that determination. I don't see any reason to step behind his review and his determination. We have cases, for example, as a matter of course on domestic violence cases, because of our administrative order, we automatically set no bond with the understanding that they will be seen at first appearance, and the first appearance judge can certainly consider bond. Given the original charge for the warrant, and given the fact that when he was arrested on the warrant, there's now a new charge involving a firearm, I'm not inclined to look behind whatever Judge Young's thinking was. I'll let you set it for a hearing in front of him. So I'm going to deny the request to set bond on count 1 on his warrant. He'll stay on a no bond status pending disposition of that case or.
Judge, is this, I'm confused. I don't think this is an Osceola County case.
All right, Judge Wilson's case. It looked like Judge Young signed it, so he was probably the duty judge that signed it. So again, you can still hear it in front of Judge Wilson.
All right.
Conduct a full-blown Arthur hearing, and she may agree with you, she may not.
All right, thank you very much, Your
All
Honor.
right,
It's
you're
good to
welcome.
see you, sir.
Okay, so now, looks like I have Ricardo Chavez. All right, good afternoon, sir. You've been arrested on a violation of probation warrant. The judge who signed the warrant set your bond at none. I'll stay your bond at none pending disposition of your violation of probation, all right? That's what a court in regards to Mr. Chavez. This paperwork's kind of coming loose here, I'm sorry.
Just take that with
Next is Leon Dudnath. Tell me your name, sir. Student Ath, you've been arrested on a violation of probation warrant. The judge who issued your warrant, and that's in case number 21 CT 2373. The judge who issued that warrant set your bond at none. I'll stay your bond at none pending disposition of your violation of probation.
Your Honor, I just want to clarify, is it 2273 or just 273?
2273.
Thank you, Your Honor.
Next is Arthur Corbett. Tell me your name, sir.
Corbett, Arthur.
All right, sir. Just want to make sure I've got handle on. First thing I want to talk to you about is your arrest on a warrant in 2022 CF 332684. I think that's the case number. Count 1, battery by strangulation. Count 2, obstructing justice by tampering with a witness. And count 3, battery and act of domestic violence. In that case, on count 1, I'm going to set bond to the amount of $1,000. Count 2, I'm going to stay bond to the amount of $1,000. Count 3, I'll set bond to the amount of $100. I'll order, if you post bond, that you have no contact whatsoever with the identified victim. I'll order that you maintain a separate residence from the identified victim. I will allow you to return to any shared residence one time in the company of law enforcement to recover any personal items you need to survive while the case is pending. I'm going to order that you not possess any weapons, firearms, or ammunition. While you're on bond, I'll also order that you surrender all weapons or firearms in your possession to the sheriff's office within 24 hours of your release. Is this a separate case, or is this the same warrant again? Okay. Then there is your actual arrest on December 16th for a new allegation of battery and act of domestic violence. I find probable cause for that offense as well. I'm going to set bond in that case in the amount of $5,000. I'll order that if you post bond in that case, you have no contact whatsoever with the identified victim. Maintain a separate residence. I'll let you return again one time to any shared residence in the company of law enforcement to cover any personal items while your case is pending. Order that you not possess any weapons, firearms, or ammunition. Again, if you own any weapons or firearms, surrender them to the custody of the sheriff's office while the case is pending. And in this case, I'm going to order that you not possess or consume any alcohol or illegal drugs while your case is pending. That is the order of the court in regards to Mr. Corbett's two cases.
Your Honor, can we just verify that felony case?
22 CF 11232.
32, okay, thank you.
I think what they had listed for me was the agency case number.
Oh, okay, that was, okay.
Next is Jefferson Florestal. Is that your name, sir?
Yes, sir.
All right, sir. You've been arrested on a warrant. The judge who signed the warrant was for two charges. The first is sexual battery. The second is battery and act of domestic violence. As to count 1, I'm going to set your bond to the amount of $50,000. In count 2, I'm going to set bond to the amount of $1,000. I'll make a condition of bond in each case that you have no contact whatsoever with the identified victim. I'll order that you maintain a separate residence while the case is pending. If you and the victim were still living in a shared residence, I'll let you return to that shared residence one time in the company of law enforcement to recover any personal items that you might need while your case is pending. I'll order that you not possess any weapons, firearms, or ammunition while the case is pending. State any of the conditions you're going to ask me to impose.
No, Your Honor, that covers it. Was that 100 or 1,000 for the battery?
It's
The second battery, sorry.
1,000.
Thank you.
That's the order of the court. Next is Kayla Vasquez. Tell me your name, ma'am.
Kayla Vasquez.
And it appears we have someone present who wants to address the court. Can we swear him in?
Raise your right hand. Do you solemnly swear affirm the testimony you shall give be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
State your name for the record.
Jeremiah Kinlock.
Sir, how are you associated with the victim or the defendant in this matter?
She's the mother of my child.
And are you the identified victim in this case?
Allegedly victim, yes.
Okay. What is it that you want to tell the court?
I just want to tell the court that Miss Kayla, like, she's not violent in any way. And like, well, I didn't press charges on her, but I seen that the charge was on there. And like, I believe that she just acted out of fear, you know, and I just, like, I want contact with her because like she don't really have a lot of people on her side. So I want to make sure that she's okay while she's in here. So I want to come see her. I want to call her. I mean, well, I want her to call me so I can know exactly what's going on in the case, you know, so I can get her the help that she needs.
What do you think she needs help with?
Maybe a little bit of mental health, you know, I just want contact with her so I can make sure that she's okay, basically. Yeah.
State, do you want to ask any questions?
No questions at this time.
Public Defender, do you want to ask any questions?
Sure, Your Honor.
All right. Thank you, sir. You can step back. All right, ma'am, you have been arrested and charged with 2 offenses. Count 1 is aggravated assault with a firearm. Count 2 is possession of a firearm by a convicted felon. I do find probable cause for each of those offenses. While I've understood the victim's decision that he'd like to have contact with the defendant, given the factual allegations and the fact that law enforcement recovered physical evidence that would suggest that the original version of events is an accurate recitation of what took place, I'm going to set bond as follows with the following conditions. On count 1, bond will be $2,500. Count 2, bond will be $2,500. Listen very carefully, ma'am. I'm going to order that you have no contact whatsoever with the identified victim. Ma'am, this is a court order. The victim certainly has his opinion, and it's certainly something the state attorney's office may consider. It's something I considered. I'm ordering you to have no contact with him. If you violate my order, go ahead, you can sign.
Okay, I'm sorry.
And I'll finish explaining to you. If you violate my order, it won't be a defense that, well, he wanted me to call. He invited me to come over. He said, look, I'm going to go down to the state attorney's office. I'm going to say this. I'm going to say that. I want to, you know, all the things he said here. He wants to be in your life and help you. You can't have contact with him. Do you understand me? Until a judge says you're allowed to have contact, or until the case is dismissed, you have to follow this order. Do you understand? I order that you maintain a separate residence from the defendant while the case is pending. If there was a shared residence, it wasn't clear to me from the facts, you may return one time in the company of law enforcement to cover whatever personal items you need while the case is pending. I'm going to order that you not possess any weapons, firearms, or ammunition while this case is pending. Do you understand, ma'am?
Yes, sir.
State any other conditions you're going to ask me to impose.
Yes, Your Honor, we would just be asking that she comply with any plans set in place by DCF.
And we'll also order, while this case is pending, if the Department of Children and Families enters any plans around this incident, you need to comply with that as well. Do you understand?
Yes, sir.
All right, that's the order of the court.
Here you go.
Next is Anthony Barber.
Sir.
All right, Mr. Barber, you've got 2 matters before the court. The first issue is your arrest for the offense of battery and active dating violence. I do find probable cause for that offense. I'm going to set bond to the amount of $500, and I'm going to order, if you post bond, the following conditions. Number 1, you have no contact whatsoever with the identified victim. Number 2, you maintain a separate residence from the identified victim. Number 3, If there was a shared residence, I'll let you return one time in the company of law enforcement to recover whatever personal items you need to survive while your case is pending.
Stay away, sir.
Number 4,
Stay away.
okay. Number 4, I'm order that you not possess any weapons, firearms, or ammunition while you're on release. Now, that takes us to your second issue. When this incident took place, you were out on release in 2022 CF 5293 for the offense of fleeing or attempting to elude a law enforcement officer. In that case, I'm going to revoke your bond, forfeit your bond, I'm going to revoke your release status, and I'm going to order that you be held on a no bond status on that case until disposition of the case or until the assigned division judge enters a separate order. Do you understand?
Yes, sir.
That's what the court in regards to Mr. Barber. Tell me your name, ma'am.
Jacayla Britton.
All right, Ms. Britton, you've been arrested on the offense of battery. I do find probable cause for that offense. It appears you qualify for release through the pretrial release program, so I'll order your release through the pretrial release program with the following conditions. Number 1, you have no contact with the identified victim. Number 2, I'm going to order that you maintain a separate residence from the identified victim. If there was a shared residence, I'll let you return one time in the company of law enforcement to recover any personal items you need while the case is pending. Order that you not possess any weapons, firearms, or ammunition while this case is pending. That is the order of the court in regards to Ms. Britton.
Thank you.
Tell me your name, sir.
Eric Lopez.
All right, so Mr. Lopez,
Your Honor, his victim stepped out to go to the restroom.
okay. I have a question for the court staff. I'm not sure who it is. This allegation is violation of pretrial release condition. There's reference to an active misdemeanor case. Did y'all,
Is that case 2022 MM8319?
it is.
It intertwines with this case as well, Your Honor.
Correct, but typically in these circumstances, I would expect to see an order. Count 1 in this case is a crime. You can actually be prosecuted for violating pretrial release condition, which I'm reading this as probable cause to believe he committed that crime. It's a separate issue on whether I address his release status on the current case. So, let's do this. Let's go ahead and swear in and identify this witness, and then I'll tell you how I want to
I
proceed.
swear affirm the testimony shall give me the truth, the whole truth, and nothing but the truth.
Swear.
State your name for the record.
Regla Sanchez.
Ma'am, how are you connected or related to the defendant?
He is my fiance, and I am currently pregnant with his child.
Okay. And were you the identified victim in 2022 MM8319?
Yes.
And what are you asking me to do, ma'am?
I am asking to please let me have contact with him as I want and need contact. I am actually due this month on the 26th, and I don't have any family, friends, or any relatives but him. And I really am hoping to not have to deliver our child by myself.
Ma'am, do you have other children?
Yes, sir. I have 2 children that only know him as their father figure.
Is he the biological father of those children?
No, sir, but he's been raising them. That's the only father figure they know.
Is there a DCF case plan in regards to those children?
Yes, sir. They're currently now they are with me right now. They're getting picked up tomorrow with their grandma. It was actually already as the plan since I'm giving birth.
State, any questions?
The state has no questions, but I do have an argument as to release.
Okay. Madam Public Defender, any questions?
No questions, Your Honor.
All right. Go ahead, State.
Yes, Your Honor. For the case that's open involving the case 22 MM8319, The violation of that case, we would ask that he forfeit his bond and be held at no bond. He is set for arraignment on January 15th on that case, based off the allegations and the facts of that case. While I appreciate the victim's desires, I do have concern for her safety as well as the children's.
Madam Public Defender, argument?
Your Honor, I do understand the state's position in this case, but based off of the facts of the reasoning for him being here, I do know that there was a no contact order in place, but we'd like the court to take into consideration that there were no allegations of violence at this time. He was just staying with her, and she has stated that she is wishing for her help with her children. And I have explained to Mr. Lopez that there is a no contact order in place. If he needs to get that changed, he does need to contact his public defender so the appropriate motions can be filed. So though I do understand the state's position, I'd like the court to take that into consideration.
In the case that's before the court at this moment, 2022 MM 8451, in that case, I'm going to set bond in the amount of $2,500. And again, sir, I'm under the exact same no contact order that was entered in your prior case. No contact whatsoever with the identified victim. I'm going to order that you maintain a separate residence from the victim. I'm order you not possess any weapons, firearms, or ammunition. Now that takes us to 2022 MM 8319. In that case, I am going to revoke your release. I'm going to forfeit any bond that was previously issued, and I'm ordering you to be held on a no bond status until that case is resolved or until the assigned division judge rules differently. Again, while I listened to the victim's desire to have you in her life because she feels like she needs your support, my concern is there was already a DCF case plan based on the prior incident. One of the worst things that can happen to children is to be in a home where violence is used to resolve the many, many problems that couples go through in their everyday life. So I am going to order that you be held on no bond status. Can someone generate me an order for that? Yes, I am. All right, and I'll go ahead and sign that order. That is the order of the court in regards to Mr. Lopez in this situation. All right.
Your Honor, I just have one question. On the 22 MM 8319 case, is the public defender's office already appointed? If not, can we be appointed?
I don't know.
Yes, you are appointed.
All right.
Thank you.
Sir, tell me your name.
Michael Reyes.
Clerk. Mr. Reyes, you've been arrested for the offense of battery. I do find probable cause for that offense. I'm going to set bond, hold on a second. I'm going to set bond the amount of $500. If you post bond, I'm going to order the following. Number one, that you have no contact with the identified victim. Number two, you maintain a separate residence from the identified victim. Number three, I'll let you return to the residence where this incident took place one time in the company of law enforcement to recover any personal items you need while your case is pending. Order that you not possess or consume any alcohol or illegal drugs while you're on bond. And order that you not possess any weapons, firearms, or ammunition while you are on bond in this matter. That is the order of the court in regards to Mr. Reyes. How much was the bond? 500. Good afternoon, ma'am. Tell me your name.
Jennifer Salim.
Ms. Salim, you've been arrested for the offense of battery, an act of domestic violence. I do find probable cause for that offense. It appears that you qualify for release through the pretrial release program. So I'll order your release through the pretrial release program with the following conditions. Number one, that you have no contact with the identified victim while this case is pending. No contact means no contact. Number two, I'm going to order that you maintain a separate residence from the identified victim while the case is pending. I will allow you to return one time in the company of law enforcement to any shared residence to recover any personal items you need while the case is pending. Order that you not possess any weapons, firearms, or ammunition. That is the order of the court in regards to Ms. Salim. Tell me your name, ma'am.
Amberly Shorter.
All right, ma'am, you've been arrested for the offense of battery and active domestic violence. I do find probable cause for that offense. It appears you qualify for pretrial release, so I'll order your release through the pretrial release program with the following conditions. Number one, you have no contact whatsoever with the identified victim. Number two, you maintain a separate residence from the identified victim. Number three, I'll let you return one time in the company of law enforcement to any shared residence to recover whatever personal items you need while the case is pending. And number four, I'll order that you not possess any weapons, firearms, or ammunition while the case is
I don't like
pending.
guns, sir.
It's all right. That's the order of the court in regards to Ms. Shorter.
Thank you, sir.
All right. One time. Afternoon, sir. Tell me your name. Mr. Bagby, you've been arrested on a warrant in 22 CF 618. Count one is for the offense of attempted second-degree murder with a weapon, and count two, aggravated battery with a deadly weapon or causing great bodily harm. This actually is a failure to appear warrant. The judge who issued your warrant set your bond at none. I'll stay your bond at none pending disposition of your case or further order of the judge assigned to your case. Good afternoon, sir. Tell me your name.
That was Brian, sir.
All right, Mr. Bryan, you've got a couple different things here. The first is your new arrest for possession of methamphetamine and attempted tampering with evidence. I find probable cause for each of those offenses. On count one, I'm going to set your bond at $500. On count two, I'll set your bond at $100. You also have a warrant arrest in 21 CT 2098 for the offense of driving while license is suspended. Failure to appear on that case. The judge who issued that warrant set your bond at $1,000. I'll stay your bond at $1,000 pending disposition of your case or further order of that court. All right, next. Tell me your name, sir.
George Calloway, sir.
All right, Mr. Calloway, you've been arrested on a warrant in 19 CF 4581 for failure to appear. The judge who issued that warrant set your bond at none. I'll stay your bond at none on that case. Then you have a separate failure to appear in 20 CF 4916. The judge in that case set your bond at none. I'll stay your bond at none. And then you have a third case, 2022 CF 4725. Another failure to appear. The judge who issued that warrant set your bond at none. I'll stay your bond at none pending disposition of that case or further order the division judge. That's where the court, Mr. Calloway's three cases. All right, so tell me your name.
Royal Sebastian Cambio.
All right, Mr. Cambio, you've got a bunch to talk about. So first is your arrest for multiple criminal traffic offenses, including operating a motor vehicle without a valid license, driving a license suspended or revoked, reckless driving, and operating without a motorcycle without a valid endorsement. I find probable cause for those offenses. I'll stay your bond as previously set on those four offenses.
I'm sorry, Judge, he bonded on, the only case we're addressing is the 2022 CF 14500AO. He bonded on the no valid, the reckless driving, no motorcycle license, possession of cocaine, case 2022 CF 14563.
Okay.
Bonded on all that.
All right, so sir, you've already posted bond on all those, so then the only thing that's left is 2022 CF 14500. That is a warrant case. The judge who issued the warrant in that case set bond as follows: $1,000 on count 1, grand theft, third degree of motor vehicle. Count 2, possession of firearm by a convicted felon, $500. Count 3, possession of ammunition by a convicted felon, $500. Count 4, grand theft, third degree, bond $500. Count 5, resisting officer without violence, bond $250. And count 6, driving with suspended or revoked license, bond set at $250. I'm going to stay all of those bonds. That is the order of the court in regards to Mr. Cambio.
So the other felony case,
He bonded on those.
6-3, he bonded?
You're welcome. Sir, tell me your name.
Sean Davis.
All right, Mr. Davis, you've been arrested for the offense of criminal mischief greater than $1,000. I do find probable cause for that offense. I'm going to stay your bond at $1,000. If you post your bond, we'll order that you not return to the Publix where the alleged incident took place. That is the order of the court. Next is Ralph Dixon, correct? Sir, tell me your name. Tell me your name. Ralph Dixon. All right, Mr. Dixon, you've been arrested on a warrant, sexual offender, failure to register as required by law. I'm going to set bond in the amount of $1,000 on your case, and I'm going to order if you post bond, you comply with any and all registration requirements you have as a sexual offender. Do you understand me? Do you understand?
You understand that? No. So if you post a bond and you're released, you have to comply, you have to go register. Okay?
But I'm not ready.
Okay, well, you can talk to the public defender and we'll figure out that you have a bond. Yes, I wrote it on your paper for you.
All right. Next is, come on up, sir. Tell me your name.
Good morning.
Tell me your name.
John Franklin.
All right, Mr. Franklin, you've been arrested for the offense of grand theft in the third degree of a motor vehicle. I do find probable cause for that offense. I'm going to stay your bond at $1,000. And I'll order if you post bond, you have no contact with the co-defendant Leon Dudnath. Do you understand?
Excuse me?
I said, if you post bond, I'll order that you, as a condition of your bond, you have no contact with the co-defendant Leon Dudnath. Okay? All right. That's the order of the court.
All right, thank you.
You're welcome. Tell me your name, sir.
Jared Griffin.
Mr. Griffin, you've been arrested for the offense of possession of MDMA, also commonly referred to as ecstasy. I find probable cause for that offense. I'm going to set your bond in the amount of $1,000. That's the order of the court, sir.
Anna Lakita Harris was a refusal.
Your Honor, we waive our appearance.
So, has anyone read the affidavit?
It was a tough one. It was really detailed.
I'm going to ROR Ms. Harris on those two counts. So count 1, count 2, PD's waived her appearance, and I'm going to ROR on those two.
You'll release, I got it.
At least an ROR. Tell you a story about that when we're done. Tell me your name.
Mr. Darnell Hodge.
All right. You've been arrested for the offense of possession of MDMA, also commonly referred to as ecstasy. I do find probable cause for that offense. It appears you qualify for release through the pretrial release program, so I'll order your release through the pretrial release program. Comply with all standard conditions, sir.
No alcoholic drugs, Your Honor. No alcoholic drugs.
Is that a standard condition of PTR?
Well, if we do PTR, I mean, it's your discretion, but
I'll order that you not possess or consume any illegal drugs. Illegal drugs.
Your Honor, Teresa Jankovic was a refusal.
Your Honor, we'd waive her appearance.
In regards to Ms. Jankovic, I do find probable cause for the offense. I'm going to set bond. This is a warrant arrest, correct?
Yes, Your Honor.
So it's a warrant arrest. I've reviewed it. I'm going to set bond in the amount of $1,000. That's the order of the court.
Your Honor, I do have a probable cause challenge for this one.
Tell me your name, sir.
James Irving Morris, Your Honor.
What happened to Dickneek Johnson?
I don't have that. You have a booking number, Your Honor, on the affidavit?
Booking number,
Should be.
I have an inmate number,
Yes, let me have that.
220-29350.
Bonded.
Okay. Madam Public Defender, is your ROR as to count 3? Or is your no PC as to count 3?
It would be to either count 1 or count 2. They don't think that it's super strong on the assault, but the PC challenge is that there are 2 counts of battery on a law enforcement officer. This was one continuous incident with 1 victim. So we would ask the court to ROR on 1 of those.
Well, my understanding is the allegation is that first the defendant kicked the officer and then subsequently spit on the officer.
Yes, Your
which
Honor.
would constitute 2 distinct acts.
Your Honor, it's 2 distinct acts, but it's 1 continuous event.
Okay.
So, and then there's only 1 victim.
And do you think the law says that the most under those circumstances, the law would support would be a singular conviction?
Your Honor, I believe there's case law that states if it's a continuance incident with a, and if you would like me to find it, I can look for it, but I do believe that there's case law that states that.
I'm familiar with case law on resisting with violence.
Yes, Your Honor, I believe I know which one you're talking about, that they wouldn't file on both the battery on a law enforcement officer and resisting with violence. I do know, and I can find that case law, but the case law that I'm referring to, is if there were multiple, if it was 1 continuance incident with multiple victims, then yes, it could be charged as separate incidences, but I'm stating that there's no PC because it's 1 continuous event with 1 victim.
I'm not convinced that that's the current state of the law. So as to count 1 and 2, I do find probable cause. As to count 1, I'll stay the bond at $2,500. As to count 2, I'll reduce bond to $500. As to count 3, state, I was just going to ROR the defendant because my perception of what constitutes the assault is a threat to do things in the future, which my reading of the case law, an assault requires an immediacy. So a threat to do something in the future typically doesn't constitute the crime of assault.
Yes. The state also was looking at the threat to spit on him currently at the jail. But I understand your reasoning.
I'm going to go ahead and ROR count 3. That is the order of the court in regards to Mr. Moore.
Thank you, Your Honor.
PC on counts 1, 2, and 3, but I'm going to ROR them on 3. Okay? Tell me your name.
Anquan
All right, Mr. Owens, you have been arrested on a warrant. Signed by Judge Whitehead. On count 1, robbery of firearm, he set bond at none. I'm going to stay your bond at none. Count 2, grand theft of the firearm, he set your bond at $1,000. I will stay your bond at $1,000. Count 3, battery, he set your bond at $1,000. I will reduce bond on that count to $100. Count 4, theft, he set your bond at $1,000. I'll reduce the bond to $100. I'll order, if you post bond this matter, that you have, well, you currently have no bond on count 1, but if for some reason you end up posting bond, no contact whatsoever with the identified victim, and possess no weapons, firearms, or ammunition while you're out on bond. Is that all Mr. Owens had? Was that one case?
Yes.
Okay. All right.
Your Honor, Ryan Palmer was a refusal.
Your Honor, would waive his appearance.
All right, in regards to Mr. Palmer, he's charged with 5 counts. I do find probable cause for each of the 5 counts. I'll stay his bond as previously set on each of the 5 counts. That's on his CF case number, on his CT case number, driving license suspended or revoked. I find probable cause for that. And I'll stay his bond at $500 on that charge. Sir, tell me your name.
Timothy Pollard.
All right, Mr. Pollard, you've been arrested and charged with 3 crimes. Count 1 is possession of oxycodone. Count 2 is resisting an officer without violence. Count 3 is possession of less than 20 grams of cannabis. I'll stay your bond on each of the 3 as originally set. That is the order of the court in regards to Mr. Pollard.
Kieran Robinson is mental health.
Kieran Robinson.
Your Honor, we'd waive his appearance.
Mr. Robinson has been arrested for the possession of cocaine. I do find probable cause, or excuse me, she's been arrested. I do find probable cause. I'm going to set bond in the amount of $250. Come on up, sir. Tell me your name.
Soto Claudio, Jan Soto Claudio, Your Honor.
All right. I have a Justin Robinson, booking number 220-29351.
Bond it, Your Honor.
Bonded. All right, tell me your name again, sir.
Jan Soto Claudio, Your Honor.
All right. So, sir, you, looks like have 2, looks like you have multiple cases before the court. Will start with 2022 CF 14465. In that case, you were arrested on a warrant charging 4 counts: burglary of conveyance, fraudulent use of credit card more than 2 times, credit card theft, and petty theft of $100 or more. I'll stay the bonds as previously set on each of those counts by Judge Nix Walker. Then you've got case number 2022 CF 14467. That's another warrant: burglary of conveyance, grand theft in the 3rd degree, fraudulent use of credit cards, and credit card theft. I'll stay your bonds as previously set in that warrant as well. And on each warrant, there's a no return to, if you post bond, no return to the scenes of those offenses. Is that everything we have for?
Yes, Your Honor, these are add-on cases.
Okay,
Yes, sir.
all right. That's the order of the court, sir. All right, sir, tell me your name.
Angel Vega.
All right, Mr. Vega, you got multiple matters before the court. First is your new arrest for the offense of aggravated assault. I do find probable cause for that offense. I will set bond in the amount of $2,500. I'll order if you post bond that you have no contact whatsoever with any identified victim in this case. I'll also order that you not possess any weapons, firearms, or ammunition while this case is pending. That is in 2022 CF 14579. You have another aggravated assault in 2022 CF 14580. I find probable cause there as well. I'll set bond in that case in the amount of $2,500. Again, I'll order that you have no contact with any identified victim in that case, if you end up posting bond. And then you have 2 cases where you were already out on bond. The first is 20 CF 12634. In that case, I'm going to revoke and forfeit any bonds previously posted. I'm going to order to be held on a no bond status pending disposition of that case. And then you have 2022 CF 3528. In that case, I'm going to revoke your ROR status and order that you be held on a no bond status pending disposition of that case as well, or until further order of the assigned division judge. That's the order of the court in regards to Mr. Vega. Oops, actually, nope, different Vega. Tell me your name, ma'am.
Armin Vega.
All right, Ms. Vega, you've got two separate case numbers before the court. 22 CF 14572. In that case, you're charged with possession of cocaine. I find probable cause for that offense. I'm going to stay your bond at $1,000 in that case. Then you have 22 CF 14571. In that case, you're charged with possession of cocaine with intent to sell or deliver with a weapon. I will stay your bond on that count in the amount, I find probable cause for all three counts. I'll stay your bond on count one, the amount of $15,000. Count two, possession of firearm, commission of felony. I'll stay your bond, the amount of $4,000. And count three, possession of less than 20 grams of cannabis. I'll stay your bond, the amount of $100. I'll order, if you post bond in either case, that you have no contact with any identified co-defendant. And is that everything she has? I think so. All right, that's all the court.
Derek Williams is outside medical.
Your Honor, we'd waive.
All right, so in regards to Derek Williams, he's got multiple cases. 22 CT 7134, 22 CT 7135. I think shouldn't there be a third case number for attaching tag not assigned? I don't see a third case, but I find probable cause for each of those three offenses. I'll stay the bond as previously set on those three charges. Then, under 22 CF 14551, he's got three charges. I find probable cause for each of those. I'll stay bond on each count as previously set. And then he's got a failure to appear warrant in 2022 CF 2359. And the judge who issued that warrant said his bond is none. I'll stay his bond at none until further order of the court or that case is disposed of. All right, I think that takes care of him. Afternoon, sir. Tell me your name.
My name is Robert Lamar Williams, sir.
All right, sir, you've been arrested and charged with two crimes. The first is trafficking in greater than 10 but less than 200 grams of MDMA. And count three is possession of MDMA, or excuse me, count two is possession of MDMA. I find probable cause for each of those offenses. On count one, I'm going to set your bond at $25,000. On count two, I'll set your bond at $1,000. Do you have anything else before the court? I think that's it. That's the order of the court, sir. Yes, ma'am. Yep. Let me get my paperwork. It's all sticking together now. Sir, tell me your name.
Deepak Sagolam, sir.
So question for the court staff. This looks like another case where he's now been arrested for violation of conditions of pretrial release under a new case number of 22 MM 8401. I do find probable cause for that offense, but there's an underlying pending case, and I don't recall seeing an order revoking release on that case. Does anyone happen to know what his underlying case number is
Underlying case number is 2021 CF 5428, Your Honor.
5428. Based on this probable cause, I'm going to revoke his bond, forfeit his bond, revoke his release in that felony case number.
The 5428.
Yes.
In order he be held on a no bond status on that case pending disposition. If he posts bond on this new case, I order he have no contact whatsoever with the victim. And I believe that'll be everything. That's the order of the court in regards to Mr. Seagolan.
Your Honor, what was the bond on this new case?
The new misdemeanor case is $10,000.
Thank you, Your Honor.
Good afternoon, sir. Tell me your name.
Alvin Ross Shoemaker.
Give me one moment. I had a Ysidro Rhea, inmate number 220-29361.
Bonded, Your Honor.
Okay, that takes care of that. So, Mr. Shoemaker, you've been arrested for the offense of driving with a license suspended or revoked. I do find probable cause for that offense. I'm going to set bond in that offense in the amount of $1,500, and I'm going to order that if you post bond in that case, you not possess or consume any alcoholic beverages, not possess or consume any illegal drugs, and I'm going to order you not operate a motor vehicle without a valid privilege to operate a motor vehicle. Do you understand those conditions, sir?
Yes, Your Honor.
All right. That's the order of court in regards to Mr. Shoemaker. You're welcome.
Are you ready for bond?
No alcohol, no illegal drugs, no operating a vehicle without a valid privilege to drive. Tell me your name.
Ruben Stevenin.
All right, sir, you've been arrested for the offense of driving with a license suspended or revoked. I do find probable cause for that offense. I'm going to set your bond to the amount of $1,500. I'll order if you post bond that you not possess or consume any alcoholic beverages, not possess or consume any illegal drugs, and I'll order that you not operate a motor vehicle without a valid privilege to drive. Do you understand those conditions?
Yes, sir.
That's the order of the court in regards to Mr. Stevens.
Hello.
Tell me your name.
Gilbert Armand.
Ma'am, you've been arrested for the offense of battery. I do find probable cause for that offense. It appears you qualify for release to the pretrial release program. I'll order your release to the pretrial release program with the following conditions. Number one, you not return to the scene where the alleged battery took place. Number two, you have no contact with any identified victim. Do you understand those conditions, ma'am?
Yes, Your Honor.
All right. Actually, let me look at one more thing. Yep, that's fine. All right. No contact, no return.
Darby Kane is behavior?
Your Honor, we would waive.
Madam Public Defender, do you know what he's being held on other than this case? Because the affidavit says that he was in the Orange County Jail, so they came down and dropped charges on him on this case.
Your Honor, this is an add-on case, the 2022 MM844380. He is here on additional felony and misdemeanor cases. He was already IA'd for those.
All right. So on this case, I do find probable cause for the offense of petty theft. I'm going to stay his bond at $500. If you post bond in this case, order he not return to the location where the alleged theft took place and he not have any contact with the identified victim. Next.
Nathaniel Cushing Garcia is mental health.
Okay.
Your Honor, we'd waive.
All right, before we get to that case, I've got a Raquel Cunningham,
Yes, I also have a.
220-20 29356.
Bonded.
So this is another case, when I read the paperwork, it appears the defendant has an open trespassing case under case number 22 MM 6602. Trespassing and petty theft. He's got two separate cases today. Each of those cases, he's,
On the 22 MM 6602 case, he's set for arraignment on December 20th at 1 PM.
Okay.
It was filed on October 25th.
all right. So in regards to the two cases before the court today, 22 MM 8445 and 22 MM 8447, in each of those cases, I find probable cause for the offense of battery. Each case, I'm going to stay bond in the amount of $500. Each case, I'll order if he post bond that he not return to the scene of the alleged battery and not have contact with any identified victim or identified witness. In regards to 2022 MM 6602, I'm going to revoke his ROR status in that case, order that he be held on a no bond status pending disposition of his case, or in the alternative, order from the assigned division judge. So can you generate me an order on that one, and I'll sign it?
Yeah.
All right, that takes care of Mr. Cushing Garcia. Tell me your name, sir.
Jason Throckmorton.
All right, Mr. Throckmorton, you have a couple matters before the court. First is your new arrest for the offense of trespass on property after warning and resisting officer without violence.
Your Honor, the state does have an offer for both of these cases, which I've relayed to Mr. Throckmorton.
What is the offer?
An adjudication of guilt, credit for time served, and court costs.
Is the state aware that he was already out on another trespassing after warning? And have you considered the facts of that case in making this offer?
I did not. Based off the case, the facts of this specific case, we would be asking that he be revoked on the other case.
What I was planning on doing.
But I don't have an objection to him playing out based on the facts of what he's brought before us today for, as long as he doesn't go back to where he was trespassed.
And Your Honor, if I may,
Go ahead.
if the court is willing to take this offer today, we would ask for no action to be taken on the case he's out on bond on. It has not been filed on as of now.
Well, fundamentally, when the court's made aware that somebody's on any kind of release status on a case, and then there's an allegation that they're committing the exact same type of offense, even if it is a misdemeanor, the court has concerns that the defendant potentially fundamentally doesn't believe that the legal conduct's illegal, and they're gonna just continue to engage in that conduct while the case is pending, which to me is grounds to revoke the release status. So he can plea out today on this one, but I would be revoking his release on the other one, and he can take that issue up with the assigned division judge.
Yes, Your Honor. Do you want to take this? Your bond's going to revoke. You're going to have to speak to your attorney, and they're going to have to say neither no, or you can get a bond. He's not going to change his mind. I can't stop you, but I'm going to advise you not to. But I need to know if you want to take this or not. I need a signature here. Your Honor, he'd like to take an offer in these two cases.
Well, I don't know if the state's making an offer in the other case.
It's just the one case.
Oh, I'm sorry, Your Honor, I thought it was two cases, but if it's two counts, then,
The two counts.
Today's case has 2 counts,
yes, Your Honor, I can fix that.
okay?
Yeah.
We'll return this paperwork to you.
He just needs one. I need to write.
Mr. Throckmorton, you understand that you're only closing the case where you've just been arrested? Do you understand that?
I do, Your Honor.
And do you understand I'm revoking your release in your case that's still pending in Division 61? Do you understand that?
May I speak, may I make a comment regarding that?
I just need to know if you understand. I don't want you
yes, sir.
back there complaining that I thought I was getting out of jail. What do you mean I have to stay until this other case is addressed? Okay?
I do, I just don't understand how to take care of that, because this new case.
Mr. Throckmorton, I'm not going to tell you what decision to make. I just want you to explain that you can close this one, but it's not going to close the other one, and I'm going to revoke your release on the other one. Understand that. Do you want to go ahead and take this time served plea on today's case?
I do.
I've been handed this plea form. Do you understand all the rights you're giving up?
I do.
Do you understand the public defender's not going to do any more work on this case?
Yes, I do, yes, sir.
Did you sign the form?
Yes, sir.
Do you understand I'll be required to order that you pay court costs? I'll give you 1 year to do that. Do you understand that?
Yes, sir.
All right. Sir, I'm going to accept your plea. I find you alert and intelligent. You understand the nature of the charge against you, represented by competent counsel, with whom you say you're satisfied, and I do find a factual basis. I will accept the plea on today's case. As to each count, I'll adjudicate you guilty. As to each count, I'll sentence you to time served of
2 days?
2 days in the Orange County Jail with credit for 2 days' time served. I'll order that you pay all statutorily required fines, fees, and costs for that misdemeanor offense. Madam Clerk, can you tell me what that number is? Sir, I'll give you 1 year. Mr. Throckmorton, I'll give you 1 year from today's date to pay the $273 in full, or I'll give you 90 days from today's date to contact the clerk of the court, room 410 of the downtown courthouse, and set up a payment plan to pay off your costs. Do you understand those two choices?
Yes, Your Honor.
As to 2022 MM 7286, which is his pending trespass, I'm going to revoke his ROR status, or they be held on a no bond status on that case until that case is resolved or until the division judge makes a different determination.
Your Honor, what case number do you have? I think I have a
On the paperwork, it appears to be 2022 MM 7286.
Thank you, Your Honor.
Okay. Tell me your name, sir.
Jonathan Gomez.
Before we go to Mr. Gomez, I had a Severius Epps.
Oh, Your Honor, may I have,
He was an out-of-county warrant with a bond.
let's see.
You want an inmate number?
Yes, please, Judge.
220-29224.
Yes, he bonding, Judge.
All right, Mr. Gomez, you've been arrested on a warrant out of Hillsborough County, under Hillsborough County case number 21 CF 12418 for violation of probation. The judge who issued your warrant set your bond at none. I'll stay your bond at none. You'll sit here until Hillsborough County comes and picks you up and takes you over there to resolve your VOP.
Okay. Is
Right.
there any way to get a bond?
Nope.
And how long does it usually take for transfers?
Nowadays, I can't really guess. I would like to think within 2 weeks, but
Alright.
Hillsborough.
It's 3 days?
Yeah.
All right. Tell me your name, sir.
Newton Harris.
Mr. Harris, you've been arrested on a warrant out of, looks like out of Polk County. Trying to see if I can, the case number they have listed is CF 22010076. The judge who issued that warrant on count 1, aggravated battery with a firearm, set your bond at none. Your count 2, possession of firearm by convicted felon, the bond is set at $5,000. I'll stay your bond as set by the judge. You'll sit here until Polk County comes to get you, sir, all right? Well, actually, does Mr. Harris have a separate warrant?
CT 18, yes. That's
I'm
the
sorry, sir, you have
500,000.
another warrant out of Polk County in CT 18006420LD. In that case, your bond was set at $500. You're welcome.
About 3 days, too, the most?
Both three.
It's Polk County, hard to tell.
Three days.
Okay? All right. Tell me your name, sir. All right, Mr. Justice, you've been arrested on a violation of probation warrant on well, you've been arrested for violating probation on a Seminole County case. The judge the officer who made your arrest was an on-view arrest for violation of probation. I do find probable cause to believe that you willfully violated your probation. Your VOP is set at none at this point, pending a filing of affidavit in front of the judge in Seminole County. Just trying to make sure, there's a second affidavit, but I think it's just a duplicate. Looks like it has the same case number. Okay, all right. All right, sir, you're on a no bond status pending Seminole County coming and getting you. Next is, tell me your name, sir. Sir, you've been arrested on a warrant out of Osceola County for violation of probation. The judge who issued your warrant sets your bond at none. I'll stay your bond at none pending you being picked up. Again, just want to see if he's got a second warrant.
Just me, Your Honor.
Nope, this looks like a
The officer.
duplicate as well. All right, sir. The judge who issued that warrant set your bond at none. I'm not going to second guess that at this point in time, okay?
On the paperwork, it says it's a no bond.
But we agree, he just has one VOP, correct? All right. Tell me your name. Also known as Alexi Rodriguez Lopez.
Yes.
All right. So you've been arrested on a warrant issued from Seminole County on a failure to appear. The judge who issued that warrant set your bond at none. I'll stay your bond at none. And Seminole County will come and pick you up.
Ron, he's,
That's under,
oh, okay.
oh, hold on.
I'm sorry.
That's under case number 223995 MMA. Corrections, were you about to tell me that he's on release on a pending trespass?
Yes, Judge.
I'm not going to take any action on trespass because I don't know if the basis for the warrant before or after he was on release in this case. So there'll be no action on his pending Orange County no trespass.
Okay, Ron, did you went over both the other county as well? He had two.
Oh, I'm sorry, he had another one as well.
Yes.
That's, whoa, does he have three?
Two. I have two.
Okay. Sir, you also have a Lake County warrant for a petty theft. The judge who issued that warrant set your bond at none as well. So I'll stay your bond at none on that case as well. So I'm not sure who's going to get you first, Lake or Seminole, but whenever they're done, then they'll take you to the next county to resolve your cases, all right?
Judge, I'm sorry. I believe there was a bond on the 22 MM 6948.
It says bond amount none, 0.0. So I was relying on the paperwork that they,
That's a bond on mine.
I mean, if the actual warrant has a bond, then that's what I'm going to go with.
Let me see.
It does look like there's a $1,000 bond. So in regards to his Lake County,
1,000 and 1,500.
the bond's actually $1,000. I'll stay at 1,000. All right, so that's, should be all your cases. Good afternoon, tell me your name.
How you doing? My name is Shalini Ross.
All right, you're here before the court on a warrant out of Volusia County, principal to aggravated battery on a pregnant person. The judge who issued your warrant set your bond at $25,000. I'm going to stay your bond at $25,000. So you can either post bond and then appear in Volusia, or wait for Volusia to pick you up, bring you over there, and you can talk to the judge over there about a bond reduction, all right?
You said how much was the bond?
25,000. Tell me your name.
Jafet Andrellin.
I have a Martin Taylor. Looks like an Okeechobee warrant. Do you want a booking
Yes,
number?
Yes, Your Honor, please.
220-29254.
Bonded, Your Honor.
All right. Tell me your name again.
Jafet Andrellin.
Okay. I also had a Jasmine Villanueva.
Okay, Judge, what's her booking number? She may have bonded as well.
It's a $95 bond. That's my assumption.
Oh, okay,
All right.
she may be out there.
It's a very specific number.
Yeah.
It means something to someone. All right, now we're to Mr. Andrillin. So you've been arrested. We got a couple matters for the court. First matter is your new arrest for 2022 CF 14584. In that case, you've been arrested for grand theft, third degree of motor vehicle, count 2, possession of burglary tools, count 3, carrying a concealed weapon. I do find probable cause for each of those offenses. I'll stay your bond as previously said on each of those offenses. Then there's an allegation that at the time of these offenses, you were on probation out of an Osceola County case. I do find probable cause to believe you willfully violated your probation. I'm actually going to set your bond at none on that case. I will ask Orange County Corrections to contact Florida Department of Corrections probation patrol, make them aware of this arrest, and ask them to file an affidavit in the Osceola County
Do
case.
they have a hold for Osceola County for that, Your Honor? There's a hold in place.
Okay, all right. Is that, I see another violation of probation. That's what I thought was the same.
No,
Right.
it's the same.
No, that's fine.
good.
That's fine.
He's good.
I'm being careful. That's it. I promise to do much better tomorrow. Tell me your name.
John Berryhill.
Mr. Berryhill, you've been arrested on a violation of probation warrant in case number 19 CF 12726. The judge who set your, or issued the warrant, set your bond at none. You'll remain on a no bond status pending disposition of your violation or further order of your assigned division judge. Next. Name?
Jelani Jones.
All right. You've been arrested on a violation of probation warrant, 2022 CF 3418, Division 16. The judge who issued your warrant set your bond at none. I'll stay your bond at none pending disposition of that violation. Then you have your new arrest for possession of cocaine with intent to sell or deliver. I find probable cause for that offense. I'll stay your bond at $15,000 on that case. That's go to the court in regards to Mr. Jones. You're welcome.
Elwood Ranellis was a refusal.
Your Honor, we'd waive.
All right, so Mr. Vanellis had a violation of probation in 19 CF 7307 BO. In that case, his bonds stayed at none. And then he's got his new arrest, possession of firearm by convicted felon. That's a warrant arrest. The judge who issued the warrant set bond at $2,500. Will stay bond at $2,500 pending disposition of that case.
John Doe was a refusal.
Your Honor, can we reset?
Which defendant are we talking about?
John Doe.
John Doe. Are we gonna know who John Doe is by tomorrow?
Your Honor, we still, hopefully, if we can, let me see if he was even fingerprinted. I don't believe so.
All right,
Got a name.
we'll recall John Doe for first appearance tomorrow.
Yeah, he's still in the printing process.
Okay,
And Jamara Pacheco Rosado was a bond.
okay. I have no more affidavits in front of me. Does that mean I'm done?
Yeah.
Okay,
So this last person bonded?
correct. Does anyone want this collection of these pages that separate the docket?
Your Honor, I'll take that.
Not those.
Not those, the other fish.
You could throw that one away.
She's got everything else.
She want these.
Yeah, yeah, I'll take those right there. That's
Oh, I need to sign these orders, don't I?
Oh, yes, no comment.
Oh, goodness.
So those you could throw away, yeah.
Your Honor, are we gonna do same time tomorrow?
That's, my plan, so some of it's gonna depend on how much paperwork I have to get through, and again, I'm planning to start Osceola at 10:30, and then just depending on how much I got done before I started Osceola with this, will determine whether I'll probably end up taking another break to finish reading and then come back, because I saw a big nasty note suggesting I'm not supposed to sit here and read in session, so.
Hi, Dom. See you tomorrow.
Big, it's on the whiteboard in there. Do not read on the bench, so.
Does that mean we all get to go home? Because I'm not a defense attorney, but do not read on the bench would mean don't read anything on the bench.
No, I think what it means is go back to that little frigid chamber and read everything first so that we don't, and I get it. Some
No, it's
people,
understandable.
sometimes it takes a while to read. I mean, I thought I was gonna be ready a lot sooner than I was today, so.
Well, I'm gonna go figure out how to do a 33-day motion.
There you go. That's the great thing about this job. You're always learning something.
Oh, yes.
All right. You too.
Morning, sir. Tell me your name. Can you say that again? That microphone doesn't appear to be working correctly. Can someone check it? Okay. All right. Tell me your name again, sir.
Richard Crump, Your Honor.
All right, Mr. Crump, you've been arrested for the offense of stalking. I do find probable cause for that offense. I'm going to set your bond at $500, and I'm going to order, if you post bond, that you release through the pretrial release program. I'm going to order that you have no contact whatsoever with the identified victim at this point in time. That means no phone calls, no text messages, no letters, no contact whatsoever. Now, listen carefully. If your family court judge on your pending case enters an order allowing you to have contact for purposes of child custody and or visitation, then you can have contact as defined in that order. But until such an order is entered, no contact whatsoever. Do you understand me, sir?
Completely, sir.
All right. That is the order of the court in regards to Mr. Crump.
So it's just $500?
$500 and PTR, all standard PTR conditions and the no contact as I just set out. Next is Mohammed Drury.
Hello.
All right, tell me your name, sir.
Mohammed Dory.
All right, Mr. Drury, you've got two different warrants before the court. In the first warrant, you have two counts. One is burglary structure while armed. The other is grand theft of a firearm. I'm going to stay your bond as set on that warrant originally. I'll order that if you post bond, that you not return to the scene of the alleged burglary or theft and have no contact with any identified victim or witness. Then you have your next case, which I believe is, I'll tell you in a second. A case, another warrant with, looks like 7 counts, including burglary of structure or conveyance while armed, grand theft of a firearm, petty theft of first degree, 3 counts of credit card fraud. I'm going to stay your bonds as previously set. In that warrant, I'm going to order you not return to the alleged scenes of any thefts and any fraudulent use of credit cards, and I'll order that you have no contact with any identified victim. And then finally, sir, it's my understanding that you're currently on bond on 2 active Osceola County cases, 2022 CT 3766 and 2022 CT 3879. I'm going to revoke your bond, forfeit your bond, and revoke your release in each of those 2 cases in order that you be held on a no bond status on those 2 cases, pending disposition or order of the assigned division judge. I believe that takes care of everything on Mr. Drury's case.
Your Honor, Crystal Osborne, pre-trial release, can you repeat those cases that you say he was out on bond on?
I only said it because your information sheet had that information on it. So it's Osceola case 22 CT 3766 and Osceola case 22 CT 3879, both suspended license cases.
Okay, we had to make a correction on the paper because the warrant occurred before he was placed out on bond on those cases.
All right, then disregard what I just said. So, sir, I'm not taking any action on your 2 pending suspended license cases since the allegations on the warrant were offenses that took place before you were on bond. So disregard what I said about revoking and being held on a no bond status.
All right.
Thank you, corrections.
Thank you.
Next is Taylor Mignot. Tell me your name, sir.
Taylor Mignot.
Mr. Mignot, you've been arrested for 2 offenses. The first is battery on a person who is pregnant, and the second is domestic battery by strangulation. I find probable cause for each of those offenses. I'm going to, on count 1, set bond in the amount of $1,000. On count 2, I'm going to set bond in the amount of $500. I'm also going to order on each count that if you release, it's bond plus pretrial release with all standard conditions of pretrial release and the following conditions as well. Number 1, you have no contact whatsoever with the identified victim in this case. Number 2, no contact with any identified witness in this case. Number 3, maintain a separate residence from the identified victim. Number 4, I'll let you return to the scene where this took place 1 time in the company of law enforcement to recover any personal items you might have there for the pendency of this case. I'll also order that you not possess any weapons, firearms, or ammunition. All of those are conditions of your bond and your pretrial release in this case. That's the order of the court in regard to Mr. Mignot. That's it. Next is Andreas Pinto Garcia. Tell me your name, sir.
Andres Pinto.
Okay. Mr. Pinto, you've been arrested for the offense of battery. I do find probable cause for that offense. I'm going to set bond in the amount of $500 and order that if you post bond that you also release through the pretrial release program. So that's bond and pretrial release. I'll order that you comply with all conditions of pretrial release. I'm seeing in the paperwork that the identified victim wants to have contact with you, so your conditions of pretrial release on top of all standard conditions will be no hostile or violent contact with the identified victim. I'm also going to order that you not possess any weapons, firearms, or ammunition while you're on bond and pretrial release. That is the order of the court in regards to Mr. Pinto. Next is Angelia Valdez. Good morning, ma'am. Tell me your name.
Good morning, Angelia Valdez.
Ma'am, you've been arrested on a warrant out of Orange County. The judge who issued your warrant set your bond in the amount of $1,500. I'm going to stay your bond at $1,500. You can either post bond and go to Orange County yourself or wait for Orange County to come and pick you up, all right?
Okay,
All right, that's the order of the court in regards to Ms. Valdez.
thank you.
You're welcome. Next, I have a James Earl Bronson.
Your Honor, he refused to come down, and I know he did, yes, this is a reset from yesterday. If we could waive his appearance today?
All right, I found probable cause. I'm going to stay his bonds as previously set in the amount of $1,000 on count one and $500 on count two. Next is Christopher Hasley.
Another refusal, Your Honor, if we could waive his appearance?
All right, he was arrested on a violation of probation or community control warrant. I'm going to stay the bond at none as the issuing judge set. That's where the court in regards to Mr. Hasley. And then Glenn Penson.
He's approaching, Your Honor. He's in a wheelchair.
All right. Tell me your name, sir.
Glenn
What's your last name?
Penson, P-I-N-S-O-N.
Mr. Penson, you've been arrested for the offense of trespass after warning, and I do find probable cause for that offense. A question for the PTR staff. I don't have any paperwork on Mr. Penson since he was a reset. Does he qualify for any form of PTR?
No, sir.
All right. Mr. Penson, I'm going to stay your bond at $500. If you post bond in this matter, in order that you not return to the location where you've been trespassed from while this case is pending.
Excuse me, Your Honor. Michelle Cotano with the Public Defender's Office. Mr. Pinson is homeless. We would ask for ROR. He can't afford to bond out. I know he has another matter, but just ROR on this case?
I'll deny that request at this time. You can set it for hearing in front of the assigned division judge.
Yes, Your Honor.
All right. That's the order of the court in regards to Mr. Penson. So I think the only thing we have unaddressed is Garcia Mendez. I'm going to see if we can succeed in getting an interpreter this time.
I have Robert M. Haas.
I'll address that in just a moment.
Okay.
Good morning, Your Honor. This is Laura Arroyo, State Certified Interpreter and previously sworn.
Good morning, Ms. Arroyo. This is Judge Wooten. I'm now conducting first appearances for Osceola County. We're going to
Yes,
do
Your
a
Honor.
first appearance on a first name Everardo, last name Garcia-Mendez. Can we have that subject come up? He's now standing at the lectern. Good morning, sir. Tell me your name.
Señor, buenos días. Indique su nombre, por favor.
Everardo García Méndez.
Everardo García Méndez.
Sir, you've been arrested on a warrant out of Hillsborough County, Florida.
Señor, le detuvieron a usted debido a una orden de arresto que se emitió desde el condado de Hillsborough, Florida.
The judge who issued the warrant for the offense of grand theft sets your bond in the amount of $2,000.
El juez que emitió esa orden de arresto por una acusación de hurto de mayor cuantía fijó la fianza en $2,000.
I'm going to stay your bond at $2,000.
¿Se mantendrá la fianza en esos $2,000?
You can either post that bond and report to Hillsborough County yourself,
Usted podrá depositar esa fianza y ir y reportarse al condado de Hillsborough usted mismo,
or in the alternative, Hillsborough County will come and transport you most likely sometime in the next 3 or 4 days.
o Como alternativa, si no lo hace, entonces los del condado de Hillsborough vendrán y le transportarán a usted de regreso a Hillsborough en unos 3 o 4 días.
That is the order of the court.
Esa es la orden de este juzgado.
All right, Ms. Arroyo, I think that's the end of our need for your services for Osceola. I anticipate when I wrap up, I'll be back on in about 45 minutes or so to start addressing Orange, and I believe we'll do your cases first.
Very well, Your Honor. Thank you.
Hi. So, Osceola, in regards to Mr. Imhoff, I revoked his release status on multiple cases yesterday. The clerk's office in Osceola had those cases tagged as closed. However, a review of each of case indicates that, in fact, they are still open with proceedings set in January or February of next year. I was told that they were no longer going to ask me to address that they reached the same conclusion. But the cases are not closed at this time. I'll let the assigned division judge determine what the appropriate course of action is for Mr. Imhoff.
Yes, Your Honor, he has 3 open cases that I see that are